Hello again, Attorney Andrew Bethel here, and today we're diving deep into a topic that's causing a lot of worry among those in California who are looking for or who are already qualified for long-term care: Medi-Cal, estate recovery claims by the state. Many of you have expressed your concerns, fearing that after a lifetime of hard work, the state could swoop in and claim your home to cover medical costs after you pass away. I hear it from my clients, I hear it from my professional contacts, and I've even heard about it in the news. Before we get into it, don't forget to like and subscribe and share the video with someone you know concerned about losing their home to the state, and let's dive in. Let's first clear up some common confusion among these programs: Medi-Cal, Medicare, and Medicaid, since they're often get mixed up. Medicare is a federal program primarily for those 65 and older, providing broad healthcare coverage regardless of income. Medicaid, on the other hand, is a joint federal and state program helping individuals with limited income cover their medical costs, and it varies by states. States can adopt the baseline Medicaid rules or make the adjustments to them to fit the needs or desires of that state's citizens. Here in California, Medicaid operates as Medi-Cal, which includes some specifics like estate recovery that can deeply impact your estate planning. Medi-Cal not only helps with regular medical costs, but also covers long-term care, something Medicare generally does not. Now, I won't go into qualifying for Medi-Cal too deeply here because, well, there just isn't that much to talk about. As time has gone on, California has only become less and less restrictive when it comes to qualifying for Medi-Cal. Beginning January 1st of this year, 2024, California eliminated the asset restriction for qualification, meaning that no matter how many assets you have, you can qualify for long-term care coverage under Medi-Cal, whether it be $1 or $1 million in assets. Essentially, come to California for long-term care since the state doesn't care about your assets. However, what they do care about is your income. The more you bring in a month in income, the more you would have to pay out of pocket before Medi-Cal kicks in to cover the rest. There are some ways to lower one's income or use expenses to offset that income so as to pay less out of pocket, but that's a whole discussion in and of itself and is often case by case. However, taking a step back, I mentioned California eliminated the asset restriction for qualification, but that doesn't mean that the state doesn't care what your assets are. While the value of your assets won't prevent you from qualifying for Medi-Cal, California still wants to know what assets you have so they can know what they can potentially recover against after you die. In essence, the state comes to you with a handout saying, "So sorry to hear about your mom's passing. She did use Medi-Cal to cover the cost of her nursing home, and that cost about $130,000. Now, what are you planning on doing with her house?" This brings us to Medi-Cal recovery claims. This term might sound alarming, and rightly so. If you're on Medi-Cal and over 55, the state can recover from your estate after you pass away to reimburse for medical costs paid on your behalf. This recovery focuses on assets you own at death that are subject to probate. Yes, including your home, unless certain protections are in place. For estates of those who passed away after January 1st, 2017, recovery is limited to probate assets. This means assets that pass directly to a survivor through a trust or via instruments like transfer on death deeds, and they're generally protected. But let's be clear, this doesn't mean you are completely safe from recovery if not planned correctly. Now, how can you protect your estate from California's Medi-Cal recovery claim? The key is proper estate planning. Tools like beneficiary designations and transfer on death deeds for real property can help, but they might not cover everything, especially when it comes to assets that don't transfer automatically upon death. The most comprehensive approach involves setting up a robust estate plan centered around a revocable living trust and powers of attorney for finance and healthcare. A trust ensures your assets pass outside of probate, thus sidestepping estate recovery. Your trust will address everything: your home, your financial assets, your personal property, you name it, and can thus grab everything and provide blanket protection from probate and thus recovery claims. Powers of attorney allow your loved ones to manage and protect your estate, especially critical if long-term care and incapacity issues arise, which, if we're talking about long-term care, then this is a valid and immediate concern. Think about it. If you're going to be in a nursing home or need specialized care, then you're probably not going to be in a state to be going to banks, balancing checkbooks, and managing real estate. You've likely got people you've taken care of in your life. Let them take care of you. Speaking of transfer on death deeds, many of you have asked if using a TOD deed can protect your home from a Medi-Cal recovery claim. Good news, properties transferred through a TOD deed are not subject to a probate and thus are generally protected against Medi-Cal recovery, provided all legal requirements for the TOD deed are correctly met. However, while TOD deeds and similar instruments offer a simpler alternative to more complex trusts, they come with their own set of limitations and risks. If the beneficiary predeceases you without alternate planning, then the property could end up in probate, potentially exposing it to estate recovery, which was the whole point of avoiding in the first place. The beneficiary under a TOD deed will also be obligated to take on your unsecured creditors, like your credit card bill. Additionally, if the deed isn't recorded within a short period of time after signing, then it's effectively worthless. And perhaps most importantly, their options to sell the house after your death may be limited, as title companies are hesitant to provide title insurance for sometimes up to 3 years following your death due to the risk of challenges to the TOD deed in the first place. Our last video was actually a deep dive into revocable transfer on death deeds for here in California. I did a video on them a few years back, but a few laws have changed since then and we've learned a trick or two, so I figured now was a good time to give you an update. However, I do want to emphasize this point. Revocable transfer on death deeds are fine in a pinch, but nothing beats robust estate planning with a revocable living trust as the cornerstone. You have flexibility, umbrella coverage for your estate, and perhaps what many people appreciate the most, privacy. But I'll leave that there for today. Bringing it together, while California offers significant healthcare benefits through Medi-Cal, these can come with strings attached in the form of an estate recovery claim for what the state paid for your care during your lifetime. To ensure your property and savings are safeguarded for your family, it's crucial to consult with an estate planning attorney, hint hint, and plan your estate before you or your loved ones is no longer in a condition to do so. What are your thoughts on California's Medi-Cal program? Do you think we should get rid of the estate recovery altogether, or should we disallow people from being able to avoid it in the first place? Leave a comment below and let me know. Remember to like, subscribe, and share the video with someone who may need Medi-Cal to pay for their long-term care. I'm attorney Andrew Bethel, and I'll see you at our next meeting.